Has Suleiman defeated the Madlanga Commission? Watch as Mbuyiseli Madlanga and advocate Kameel grilled Suleiman after he refused to show up before the commission. Madlanga has had enough from Suleiman as they are set to send him to prison immediately. Did you think Suleiman deserves to be jailed? If yes, like and comment send him to prison on the comment section.
As I indicated, at least then I said the commission was minded to. Let me outright say the commission is going to set the criminal process in motion. The commission will direct the relevant functionary, and as you anticipated it, Mr. Premhid, that functionary will be Dr. Vuguza sitting across there, who is the commission secretary, and for her to lay a criminal charge, not to make a recommendation, to lay a criminal charge against Mr. Carrim. If the commission were not to do that, it would itself not be taking its processes seriously. This is something that the commission just has to do. Otherwise, witnesses will choose to come or not to come testify before it willy-nilly. And we cannot and we will not have that. So the commission will lay criminal charges against Mr. Carrim. Whether he has defenses to that, that's something for him to raise in that criminal process. Thank you. I will not even say that this is what the sort of decision that one usually has in mind in the context of decisions that are taken and which are reviewable. But of course, I can never stop Mr. Carrim taking us on review on this, but I would be very surprised if he were to do that. I'm just announcing what the commission is minded to do. I have a note. I will do a trump on my colleagues. Both of them have sent me notes. Two issues. One is that's the end of the road insofar as us having Mr. Carrim before us. That's it. Then what's happening next?
Chair, Ms. Ramsamy is ready to continue with her evidence.
What's the time now?
10.
To counter the question whether Mr. Carrim is indeed unable to come to this commission, the commission has said it wants to have him assessed by an independent specialist. He has refused that should be done. That's the assessment that the commission wants to have. It's not an assessment of Mr. Carrim's specialist. That's a simple point I'm making.
Yes.
And for Mr. Carrim to offer us his specialist, that does not assist. In fact, that actually takes us to what courts always say, the hired gun principle. Because from where we are sitting, we do not consider Mr. Carrim's doctor to be an objective expert. He is an expert that's closely associated with Mr. Carrim, and who, from where we are sitting, unless we get another opinion, appears to us to be pushing Mr. Carrim's story. So very close to, if not analogous to what courts have referred to as a hired gun. In this sense, if a court wants to get an objective view, it will want to get someone who is independent as opposed to someone who's closely associated with the person concerned. And this is exactly what we have here. A medical specialist who has been treating Mr. Carrim for this lengthy period, and who on certain facts appears to have shifted the goalposts. And why do I say so? I say so on the basis of that paragraph that I referred to during the postponement application. In fact, I referred you to more than one. There are the paragraphs where he changes his story on factual issues, not issues related to Mr. Carrim's condition, on factual issues. He changes his story because he said a patient can only go out of the facility, only, underline only, if I allow them to go out. But once we got the Woolworths and the Kauai visits, all of a sudden, the doctor now changes tack and says, oh no, actually, even nurses do allow patients out. So from where we are sitting, those are indications that this is a doctor who has so aligned himself with Mr. Carrim that sitting, I'm not saying he's lying. All I'm saying is, sitting where we are sitting, we just cannot accept what he says. We do want to have an independent assessment, which we do not have and which we will obviously never have, because this same doctor strenuously resists that. And it is best known to him why he does so. Of course, it does explain in the reports that he has given. But from where we are sitting, we cannot just accept that. So it is on that basis that I say, in accordance with jurisprudential authority, he is very much, his position is very much analogous to that of a hired gun. And it's in those instances that courts always insist on someone who is independent, someone who is objective, but as I say, we are not going to hold our breath on in that regard. We are not going to have such an independent assessment. So I say again to you, you cannot say that, you cannot respond to my point about the lack of contradiction in the manner in which you do, because that opportunity has been refused. I know I've said a lot, but respond anyhow you want to.
No, I'm indebted for the indulgence to respond. I am cautious, however, that I'm not going to take us in a circle regarding this contention, because I've understood what Chair said. I disagree with Chair's characterizations in two respects in that regard. And in fact, I think for the first time, the criticism that Chair has posited regarding the doctor has done two things with the greatest of respect. The first one is it's clarified what the actual concern is regarding the doctor's objectivity. That was the word that Chair used. And also to set out the justification as to why the independent medical exam is potentially needed because of that concern on objectivity. May I say two things in response to that, please, Chair? The first one is, I think, and I say this with all due respect, and I hope this doesn't come across as being impertinent. I think, Chair, you've actually articulated why the doctor is more necessary, not less necessary, if his objectivity is in doubt. Because if his objectivity is in doubt, which is not necessarily the same regarding the rightness or otherwise of his clinical conclusions, then it's him as the doctor offering that evidence who has to be impugned so as to demonstrate that his objectivity is justifiably in doubt, and whereafter his objectivity is justifiably in doubt, then the gateway mechanism to the medical examination is opened. So where I respectfully disagree with the chair is I say the conflation, and I use that word respectfully, I obviously don't mean it in a personal way, but the conflation that chair has made in positing the reason for the independent medical exam to me is an objectivity issue. But if that's an objectivity issue, an independent medical exam may come to the same conclusion that this doctor has, but that doesn't do anything in respect of his objectivity or otherwise. And what I would respectfully say, and what courts do all the time, is where an independent expert is used by one side or another as to evidential issues and legal conclusions, then you don't go and bypass that particular expert to go to the underlying individual or evidence. You impugn that expert. You impugn his objectivity, whether by demonstrating he's a liar, whether by introducing your own rebuttal expert witness, or so on. That's the ordinary mechanisms of litigation. And so the conflation that I'm respectfully contending for is...
May I just say, I'm not conflating anything. We don't have to have only one reason. The reason may one be the commission wants to be sure.
Point is to say, with the greatest of respect, that the criticism, and I'm not sure if it is a direct criticism or it's an indirect criticism, that those outings, in inverted commas, are not being dealt with in the latest medical report, is also because that represents a shifting of the goalpost. This medical report, which is now in front of the Commission, explains in particular what happened after Chair's ruling on the 29th of July and what was undertaken or not undertaken in that regard. And to the extent then there are references to historical facts, that's also dealt with in this report, and those 7 or 6 other medical reports which have historically been tabled haven't been challenged in front of the Commission, and they stand as an explanation for those outings,
you see,
one way or another.
Last time, and I will repeat even now, last time when you made a similar point about these reports not being challenged, I said to you, how do you expect them to be challenged when Mr. Carrim is resisting, strenuously so, to be examined by somebody who can actually challenge those reports? So it's a non-starter for you to talk about a lack of challenge.
That's
complete non-starter.
I respectfully disagree with you for 3 reasons, and this is my third comment. In the first instance, the doctor has himself made himself available on more than one occasion to the Commission.
It's not the doctor that the Commission wants to have assessed. It's not the doctor.
Be that as it may, it's a less intrusive means that's available to the Commission in circumstances where the purpose of the examination is to run a parallel process to verify those clinical opinions. That's the purpose of getting the patient into a voluntary medical examination. The point I'm making is that the doctor...
I'll listen to the rest of your rebuttals, because you say you disagree with me, and I think you said on 3 bases.
Yes.
So the first one, I do not accept at all. You may continue arguing on it, or you may proceed to number 2 and number 3.
No, I won't. It's on the record, and that's sufficient for my purposes.
Okay.
The doctor's made himself available. Nobody's chosen to do anything about that.
Nobody wanted to assess the doctor. So
no, but
may I finish?
I apologize, Chair.
That's simply not an answer to my point.
With all due respect, though, I think we're speaking cross purposes, because what Chair is saying...
We are not. I understand you perfectly, and I'm sure that you too understand me. To counter the question whether Mr. Carrim is indeed unable to come to this commission?
Mr. Chair. The first one just relates to timing. I'm surprised to hear my learned friend complain about the fact that the 12th of August gave them insufficient time, whereas in Chair's original ruling from the 29th of July, had Mr. Carrim participated in the independent medical examination, that report was always going to be delivered by the 12th of August. And so to latch onto the date...
That was not Mr. Karim's doctor's report.
Correct. Correct.
So I don't get your point.
The point is simply to say that the 12th of August was always a line in the sand that the commissioners had itself identified that the status of Mr. Carrim would be known or not known, even flowing from the independent medical exam report.
I still don't get the point. You're talking about a different report, and the report in the ruling was to have been a different report. So I just don't get your point.
Correct.
At all.
All I'm saying is that, of course, the report was going to be different. That report was going to be pursuant to the independent medical exam. I'm not quibbling with that at all. But what that report would have done is it would have clarified Mr. Karim's status to participate in the commission by the 14th, on the 12th in any event, because he would either be excused as a consequence of that report delivered on the 12th.
Ms. Hassim is making a different point. She's saying they were not given sufficient time to decide what to do after a different report. Not the report that was expected. A different report was given at the 11th hour. That's a different point altogether.
I'm willing to accept that, and I'll come back to that point in comment number 5, if I can, about what the true status of the cooperation with the Commission has been. But if we put aside the 12th August date for the time being, can I please give you 2 references to the medical report itself, if I may? The first one comes from paginated page 220, under the heading, "The Ruling and Attempts to Obtain Mr. Karim's Decision." And what is listed at paragraph 15.3 all the way up to paragraph 15.10 on paginated page 222 is a full account of what happened regarding the ability to produce this report any sooner. And in particular, in addition to that, I'd point the Commissioner's attention to paginated page 225 at paragraph 19.2, which talks about, and how you read this with the greatest of respect is you read those paragraphs, which is the chronology paragraphs, side by side with 19.2 on paginated page 225, which talks about a medical incident which happened on the 11th of August in the morning. So the day before the report was written and tendered to the Commission, there was a medical incident which was nonetheless reported to the Commission, which impacts and explains perhaps why this report was only given when it was given. I accept the criticism might be that it should have been sooner, or it could have been sooner, but the objective evidence in front of the Commission accounts for that entire timeline, including dealing with the difficulties in obtaining instructions. That's point number 1, Chair. Point number 2, I'm not going to deal with this in any great length because Chair asked my learned friend Ms. Hassim the correct question we submit, which is that when the outings, and I'm using that in inverted commas because they're not outings, there is a clinical explanation for that, and the Commission has the medical report in front of it.
At which Mr. Carrim was present, and the evidence that's been provided, and also, for that matter, on the basis that there's certain information that has still not been furnished. The Chair is now familiar with the basic information that we've requested on just financial statements. That hasn't been forthcoming in the interim since the postponement application either. So what we would submit is that the Commission now just makes its findings based on the evidence that it currently has before it, without any further...
What kind of findings do you have in mind? I'm sure you are not referring to the postponement application because the ruling on that application was made on the basis of what was before the commission at the time of the hearing of that application. So what sort of findings do you have in mind?
Chair, I'm referring to any findings to be made on the basis of the evidence that was led on the 9th and 10th of March. So it's on the merits of what the issues are, whether it shows any of the conduct that we were presenting at the time that we felt fell within the terms of reference of the Commission.
I hear you.
So it's those findings. So the evidence we have is the evidence we got.
Yes.
And let's live with that, is what I'm proposing.
Yes.
But
and what is to be done about the issues that the evidence leaders considered to be still outstanding? There's nothing that can be done in that regard. Conclusions will just be drawn in whatever way regarding those outstanding issues.
Yes, the witness hasn't been able to make himself present to address any of that, and the Commission should follow the normal course as it would in any other hearing, in the absence of answers to draw its conclusions.
So if the outstanding matters tell an adverse story on their own without anybody speaking to them, then the Commission may draw whatever inferences in that regard.
Indeed so, Chair. That would be the normal course in any hearing, even in a court. So that's what we propose should happen going forward, except for the following, which I'd like to add as my final submission, and which is that we do request that the Commission records the non-attendance and refers this non-attendance and the record to the NPA or the relevant authority for further consideration for potential breaches of the provisions of the Commissions Act and the regulations. Chair, and the reason for that is that the Commission, through its ruling, has given Mr. Carrim a fair and objective route to establish medical unavailability. He chose not to opt for that route. The ruling is clear that the witness may only be excused on the basis of an independent report, and we don't have it. It's not a finding that's going to be made by the Commission. It's a finding that will lie elsewhere, but it needs to be referred to the relevant authority for potential violations of the Act. Those are my submissions, Chair.
Thank you, Ms. Hassim. Mr.
What I'd like to do is just to, for the purposes of the record, explain the steps and efforts that were taken from the Commission's side to give effect to the ruling, and then to come to where we are now, and what I propose we do in these circumstances. So if I can begin with the ruling. The ruling is quite clear, the ruling of 29 July. In clear terms, what it says is that Mr. Carrim is required to appear and to testify today, and that he may only do so if he is excused on the basis of an independent medical assessment.
He may only not do so.
He may only not appear.
Yes, you left out the not.
Thank you, Chair. So he may only not appear today on the basis of an independent medical assessment, which was to have taken place by the 12th of August. Immediately following the ruling, the evidence leaders took steps to obtain the names of suitable independent specialists who could attend to the task. We provided the name of such a specialist to Mr. Carrim's representatives the day after the ruling, that's the 30th of July. On the 31st of July, we received a response from Mr. Carrim's attorney saying that they had forwarded that information to the family and to the treating doctor. You'll recall Chair and Commissioners, that the ruling required that if there is no agreement on the proposal from the evidence leader's side by the 3rd of August, that then the president or the chair of the professional association should nominate an independent specialist. So we heard nothing further from Mr. Carrim's attorneys. And so we wrote again on the 3rd of August, the deadline, requesting a response by 10 a.m. on the 4th of August, especially a response as to whether Mr. Carrim has consented to an independent medical evaluation, because we were concerned with putting things in motion and putting people out unnecessarily. We also indicated in that letter of the 3rd of August that if we didn't hear back from them by 10 a.m., that we would then contact the president of the association in order to set things in motion. No response was received on the 4th of August. We approached the president, who nominated a specialist. And we thank the president of that association for responding to the Commission's requests with urgency and providing us everything that was required. And we regret if there was any inconvenience caused. The President provided us with the details of the independent specialist. This was communicated to Mr. Carrim's attorneys on the 6th of August. It was only on 12 August that the evidence leaders received the treating doctor's report, the report that Mr. Premhid has now referred the Commission to. And so the report provides to us, for the first time in this process, a detailed explanation of what is said to have occurred following the ruling on the 29th of July. Whatever may have been occurring between Mr. Carrim and his family and the treating doctors, none of that had been communicated to the evidence leaders while we were attempting to give effect to the ruling. The report essentially is an opinion by the same treating doctor as to why Mr. Carrim could not consent to an independent medical evaluation, and it provides further material information regarding, clinical information regarding his condition. Notably, it says nothing about the outings that we referred to in the postponement application, the daily outings by Mr. Carrim. There is reference to the 14 July excursion to Woolworths and to Kauai, but, and that's for the purposes of complaining that it had become public, that it had been made public.
Is the answer to that not possibly that that was dealt with within the postponement application, even by the treating doctor?
Well, it wasn't dealt with in depth by, it wasn't dealt with from the perspective of what the meaning of that is for Mr. Carrim's inability to testify now. And that's what we are concerned with now, is the current condition in the light of these daily outings. I would have expected that that would have been addressed more fully, given that it was a significant aspect of the, from the evidence leader's side, the opposition to the postponement application. But that's not the main, that's not it. The problem, the difficulty we have also with the report is that it's a lengthy report that's furnished 2 days before the hearing without any opportunity for the evidence leaders to obtain a considered expert opinion upon, expert opinion of the contents of the report, right? As the Commission is aware, there is an independent specialist that the evidence leaders have consulted and would have otherwise wanted to consult on this. But the report is expressly marked strictly private and confidential, medical privilege invoked, not for dissemination, and that it is furnished strictly and only for the consideration of the chairperson, commissioners, and the evidence leaders. That places us in a difficult position because it's prepared at a level of clinical detail, and it says so. The doctor this time says the last reports were for a layperson. This report, he says, is prepared at the level of clinical detail that's appropriate for consideration by a medical professional, but the restriction that's imposed upon its dissemination makes it impossible for us to obtain, for our own purposes, any independent assessment from an expert of that report. So where we find ourselves now is in this circular process, and we keep going around the mulberry bush with respect regarding this witness. And at the time remaining for this commission, and this is the submissions I'd like to make on how we'd go forward, Chair and Commissioners, there's limited time remaining for this commission to complete.